Hi everyone. In this part of the video, let's cover Chapter 6 of Indian Constitution, Polity by Lakshmikant. Okay, the Chapter 6 deals with citizenship. Okay, now let's get started. Basically, in a country, there are two type of people. Okay, the one is citizen, the other is aliens. The who are not citizens is called as aliens. Aliens, there are two types: friendly aliens and enemy aliens. Aliens are citizens of foreign country, where the citizens of the countries who are in friendly or cordial relationship with India, such as USA, UK, those people are called friendly aliens. Whereas the people from the country who are living in the India, okay, where the country they belong is in the state of war with India, such as Pakistan, can be considered as enemy aliens. So these enemy aliens does not enjoy the protection against arrest and detention provided by Article 22 of Indian Constitution, whereas friendly aliens enjoy this protection against arrest and detention. Now let's get started. What is like Article 5 to 11 of Indian Constitution of Part 2 deals with citizenship. Okay, it also empowers the Parliament to make any provision or law with respect to providing citizenship or removing citizenship. Okay, it also provides the methodology of repealing citizenship. Now, without delaying, let's get started. What is Article 5? According to Article 5, any person who has Indian dominion and satisfy any of the following condition can be considered as a citizen of India if he or his parents should be born within the India, or he is an original resident of India 5 years before the commencement of Constitution. Then he can be given Citizenship of India, COI, Citizenship of India. Let me tell you, Article 5 to Article 8 deals with the provisions which will provide the methodology using which we can provide citizenship of India at the time of commencement of Constitution. At the time of commencement of Constitution, who all can be given the citizenship is discussed in Article 5, 6, 7, 8, 9. 5 to 9. Sorry. Okay. At the time of commencement of Constitution. So, at the time of commencement of Constitution, any person who has Indian dominion and his parents are born in India and he has been original resident in India for a period of 5 years can be given Indian citizenship. Okay, now let's with Article 6. A person who has migrated to India, okay, and satisfying any of the following condition can be considered as Indian citizen at the time of commencement of Constitution. What are those two conditions? Suppose if the person is migrated to India after, like before 19 July 1948, then he can be given Indian citizenship. If he has migrated after 19 July 1948, and he should be given Indian citizenship only if he is 6 month original resident. He is staying in India for 6 months before filing application. Okay, before filing application, then he can be given citizenship of India. Either these two conditions. Now let's consider with Article 7. Article 7. Suppose if a person has migrated to Pakistan, suppose a person who has migrated to Pakistan after 1st March 1947, a person who has migrated to Pakistan after 1st March 1947 and has returned back to India for resettlement can be considered as Indian citizen if he has been original resident of India 6 months before filing application. Suppose if a person has migrated to Pakistan after 1947 March 1st and he has returned on 1949, suppose, and from 1949 he has been resident for a period of 6 months, then he can be considered as Indian citizenship after these 6 months if he files application. Okay, that is with respect to this article. Now, what is Article 8? A person who or whose parents or grandparents were born in India and person is residing in another country such as USA, and at the time of commencement of constitution he is residing in another country, and he has born, or his parents are born, or grandparents are born in India, can be considered as Indian citizen only provided that if he registered himself in the Indian consulate of that country. Suppose India has its embassy in USA, he should register himself at embassy of India in USA. Then he can be considered as Indian citizen. Okay. Article 9. What does Article 9 says? That no person shall be Indian citizen or deemed to be an Indian citizen if he voluntarily acquires citizenship of another country. So if I am Indian citizen, I can't be considered as Indian citizen, or a person can't be given Indian citizen if he is having a citizenship of another country. That is, so for example, if I have a citizenship of USA, I can't be given Indian citizenship. After renouncing, I can be given. If I renounce, if I give away in USA citizenship, then I can acquire Indian citizenship. What is Article 10? A person who is Indian citizen and he shall continue to be Indian citizen, but is subjected to law made by the parliament with respect to citizenship. Okay, so there will be a restriction. If certain restrictions are imposed by the law, then he should be obey that. Okay, his citizenship can be repealed also in that case. Now let's come with Article 11. This law empowers the Parliament to make any provision or law with respect to acquiring or terminating citizenship of, or other matters with respect to citizenship. So Parliament can make any law, such as 2019 Citizenship Amendment Act was passed, where most of the people didn't understand it. It is with respect to this, where the Parliament can make any provision or any amendment with respect to giving citizenship or terminating any citizenship. So this is with respect to this. You can file give for application example. Now let's consider Citizenship Act. Now let's consider Citizenship Act 1955. Okay. As we all know, Article 11 said about empowering of Parliament to make any provisions with respect to giving or taking away citizenship. So accordingly, Parliament brought a law, that is Citizenship Act 1955, which gives five methodology of acquiring Indian citizenship and terminating Indian citizenship, 3 methods. What are those 5 methods for acquiring Indian citizenship? Let's discuss that. Okay, this act provides 5 ways of acquiring citizenship. What are those? By birth. A person who is born in India, if he is born in India between commencement of Constitution 26/1/1950 and 1st July of 1987, he can be considered as Indian citizen. If he is born in India between these two dates, he can be considered as Indian citizen. If a person is born between 1st July 1987 and 3rd December 2004, he can be considered as Indian citizen, provided either of his parents should be Indian citizen. Okay, a person who is born after March 2004, 3rd December 2004, can be considered as Indian citizen, provided both the parents should be Indian citizen, but or either of the parents can be Indian citizen, but others should not be an illegal migrant. Okay, if one parent is Indian citizen, the other should not be illegal migrant, so they should not be illegally migrated to India. Okay, so these are the 3 conditions where a person can be given citizenship by descent also. Suppose if a person is born in the foreign country, can be given Indian citizenship, provided he should be if he is born between commencement of Constitution and 10th December 1992, his father should be an Indian citizen, then he can be given Indian citizenship. If he is born between 10th December 1992 and 3rd December 2004, he can be provided Indian citizenship if either of his parents is Indian citizen. Either. This is the condition. If he is born after 2004, his parents should be an Indian citizen, and they should register him in the Indian consulate within 1 year of the birth. Okay, within 1 year of the birth, he should be registered in the Indian consulate. Else, his citizenship can't be given. Okay. After 1 year, if they want to register, central government should give permission. This is continuation with respect to descent. Okay. Now let's discuss. Now let's discuss how can we acquire citizenship by registration. Suppose Indian government wants to give registration, a person can get citizenship by applying for registration for applying for getting citizenship. Okay, what are those conditions? Okay, those condition is the person should be of Indian origin and he should be ordinary resident. He should be residing in India for a period of 7 years before filing application. Immediately before filing application. Immediately means very soon back. Not you have been already a resident in 1990s and you apply in 2020. It can't happen. A person who is husband or wife or spouse of Indian citizen who can be of foreign origin, okay, and they should be ordinary resident of India for a period of 7 years. Then they can be given Indian citizenship. Okay, minor child of Indian citizen or a person of full age of capacity whose parents are Indian citizen, they can file application on which the central government can give Indian citizenship. Okay, a person of full age and capacity who or whose parents had removed like renounced Indian citizenship can be given Indian citizenship provided he should be ordinary resident in India for a period of 12 months immediately before filing application. Immediately. Okay, similarly, a person of full age and capacity who has OCI, Overseas Citizenship of India card for 5 years and should be an ordinary resident for a period of 12 months immediately before filing application. Immediately. So if I have OCI card for a period of 5 years and I want to apply for Indian citizenship, so I should go and reside in India for a period of 12 months and file application for Indian citizenship. Now let's consider what is naturalization. Okay, Indian government can provide certificate of nationalization under if they satisfy all of these conditions. The person whom the certificate of nationalization should be given, whom the certificate of nationalization the central government wishes to give, should not belong to a country from where the Indian citizen can't get certificate of naturalization. Suppose you are Brazil. It's an example, not reality. Suppose Brazil is the country which won't provide Indian certificate of naturalization, then India also won't provide Brazil people certificate of naturalization. Okay. The person should also renounce his Brazilian citizenship. Okay, it's a like citizenship of another country. It is a second condition. Citizenship of another country. Okay, the person should be an ordinary resident of India for or in service of the government or either partly or a host for a period of 12 months immediately before filing application. So, if you are filing application for naturalization, then you should be ordinary resident or in the government service or either partly or fully for a period of 12 months immediately before filing application. This is not the only condition. The other condition along with this for immediately before filing application 12 months you should have you should be ordinarily resident and you should be ordinary resident or you should be in the government service for a period of 14 years where in between time when you aggregate it should be 12 years at least. Okay, 12 years at least. Then you can be given certificate of naturalization. Sorry, this is 11 years. Sorry, this is 11 years. So when these 14 years period is aggregated, you should be residing in India or should be in the government service for a period of 11 years and immediate original resident or in service of the nation or government of India for a period of 12 months. Then you can be given certificate of naturalization. Okay, this I have said. After filing or acquiring naturalization certificate, he must renounce his foreign citizenship. Suppose if a person from UK gets naturalization certificate, he must remove his UK citizenship since India provides only single citizenship. Single citizenship. Okay. If you have any doubt, please let me know in the comment section or email me. I'll give that. Okay. I would be happy to reply you all. Okay. If suppose if India acquires any foreign territory, so people belonging to that territory will be Indian citizenship by default. Okay, that is the fifth method. So what are the acts? The acts provides the three methods for or terms and conditions for losing citizenship. What are those? Renunciation. So a person who want to give away Indian citizenship can file an application in the central government, and the central government will accept the application, then his citizenship will go. Citizenship will go. Termination. When the person acquires foreign citizenship, automatically the citizenship of India will be terminated. Deprivation. If the citizenship acquired by the person is by the means of fraud, if he has bribed, or if he shows disloyal towards Constitution of India, if he communicates with the enemy in terms of during war times, then his citizenship can be deprived. Okay. Now, what are the special provisions for citizenship of Assam Accord? This was according to Constitution Amendment Act done in 1985. The Amendment Act to Citizenship Amendment Act of 1955. Amendment done. The provisions added here are: the person who has been living in Assam before 1st January 1966 shall be Indian citizenship. Suppose if the person has arrived to Assam from Bangladesh, who should be of Indian origin, and after 1st January 1966 and has been ordinary resident since then, but provided before 25th March 1971, he can be considered as Indian citizen only. Should have. So the pre-requirement are: the person of Indian origin, he should be coming from Bangladesh, and after 1st January 1966 before 25th March 1971, and has been ordinary resident since then. He can be considered as Indian citizen for a period of 10 years from the day of recognizing as foreigners. So each 10 years he should get it extended. But the main part here is the he enjoys all the rights of Indian citizenship except right to vote. Except right to vote. Remember. Okay. Now let's discuss what is overseas citizenship of India. Okay. Let's give some introduction. In 2000, Vajpayee ji appointed a committee headed by Singhvi to recognize Indian diaspora, that is Indian people of Indian origin living in the various countries. LM Singhvi committee studied and submitted a report, and report suggested that the people of Indian origin in other countries, that is Indian diaspora people, should be given certain recognition, Indian citizenship. But Indian constitution forbids dual citizenship. So Vajpayee government brought Constitution Amendment Act 2003, where people of Indian origin residing in the 16 countries except Pakistan and Bangladesh are given overseas citizenship of India, where this was amended in 2005, and it was made for all countries except Pakistan and Bangladesh. In 2015, it was further amended, where the PIO scheme and OCI scheme was merged to form OCI card holder scheme. Okay, so existing PIO scheme people will be converted into OCI card holder scheme. So the government should announce a date from which the PIO scheme people will be converted into OCI card holder scheme. So, and the Constitution Amendment Act also added the following provisions. What are the provisions? Okay, who can be given OCI card holder? A person of full age and capacity who was born and was eligible to be a citizen of India on 26 means on the date of commencement of Constitution. A person of full age and capacity, a person of full age and capacity who has citizenship or who has citizenship, foreign citizenship, but he was citizen of India at the commencement of constitution. Means if it's confusing, suppose if a person A is residing in USA, he has USA citizenship. But if the person was an Indian citizen at the commencement of constitution, then this A person can be given OCI card holder. OCI card. Okay. Suppose a person who has like foreign citizenship, this A person has USA citizenship, and he was eligible to be a part of. He was eligible to be Indian citizen at the time of commencement of constitution. That person get OCI card. Or any person who has foreign citizen who has foreign citizenship and he belongs to any territory from India can be given OCI card, provided he should be a part of with a part or from a state within the territory of India. Or any person who is a child or granddaughter of any of the three conditions mentioned above can be considered as like can be given OCI card. The other things are a person who has a minor child of above people. These people who has OCI card or can be given OCI card, the minor child of that people can be given OCI card. The child of the parents of either of the child of the parents, if either of the parents is Indian citizen, his child can be given OCI card. So this is the condition. So these OCI cardholder people have different rights. Like these rights are mentioned by Government of India, but they can't get a right to vote, right to contest in the MLA, MP, that is general elections. They can't hold public offices such as High Court judges, Supreme Court judges, president, like that. These they don't have these rights. Okay, how can they cancel? They can cancel by submitting application. When the central government accepts, their OCI card will be cancelled. When their OCI card will be cancelled, their spouse and minor child also gets cancelled. Okay. Cancellation by the government. The government only can terminate the OCI card holder. Why? If the OCI card holder is obtained through fraud means, or he has shown or he has been disloyal towards Constitution of India, or he has communicated with enemy, then his OCI card can be cancelled. So that is with respect to citizenship. If I've covered each and every topic, and also I'll be making video separately on each topics on each chapters of Lakshmikant. If you please like the video, like, share, and subscribe. I'll be uploading videos on all the chapters. Okay, if I have any rectification to be made with respect to my explanation, please tell me, let me know in the comments. Okay, I'll be covering all the other subjects also, economics, geography, history, and all. Please subscribe, hit bell icon. So, okay, thank you. See you.